Okay, good evening. I want to thank everybody for coming out this evening, or at least taking the time to be with us today. As you may or may not know, this is our monthly webinar, and the purpose is for us at the Micklin Law Group to try to give back a little bit to the clients, consultations, and colleagues that have expressed interest in our services or who may currently be using the services. It's always nice to see some familiar faces. I appreciate some of the people I know that have checked in. I'm not going to name anybody specifically just so that it remains confidential, but I do appreciate you coming out. This is called the Divorce and New Jersey Family Court, the People, the Papers, and the Process. It is intended to give a general background of how essentially the family court works, but also mostly geared towards the divorce case process. There will be a lot of overlap information, a lot of the papers and a lot of the definitions that we may use specifically to a divorce action will also apply in many family court actions. Family court processes, just on a side note, been changed drastically. They've implemented forms that are intended to replace just general filings. So it's intended to make everything uniform, which makes that process very different from divorce, which most documents are drafted by attorneys or individuals and in their own form. So we're not really going to address the what's called an FD docket number. That's family dissolution, which is family non-dissolution. In this seminar, that's really a topic for another day. This will focus primarily on the process of divorces, but like I said, some of it does overlap. Just one quick note on the bottom, you'll see there's a date, December 12th, 2013. That's not obviously today's date. It's just on the form I wasn't able to change it. So later when this is published, you may want a recording of it. Just make a note that the date was off for any future references. That being said, let's jump into it. Today's webinar, just give you a little background of how it's supposed to go, what we're expecting to do. You may have noticed it's really at this point just a one-way communication. Unfortunately, it doesn't allow for questions verbally back and forth, which allows us to have more of a streamlined presentation. It's intended to be an hour. I'm never really sure. Sometimes it's a little less, sometimes it could be a little more, depending on how much information and how verbose I choose to be. Either way, at the end, I will give an opportunity for questions. You'll see in your sort of the keypad, or whatever you want to call it, on your screen will allow you to submit comments. So at the end, I will go through them. Whether the seminar is shorter or longer than necessary, I will take as much time as necessary to make sure to field everybody's questions and field them to your satisfaction. I apologize in advance if we do go over and unfortunately you're not able to stay, but this is going to be recorded, so I can email you a copy. You can listen to it at your leisure, and then if there's any questions that you have following that review of the recording, you can certainly email me or give me a call or whatever's going to be most convenient. So just a little background for those of you who may not be familiar with me and my firm. My name is Brad Micklin. I'm the senior attorney and managing member of the Micklin Law Group. I am licensed to practice law in the states of New Jersey and Pennsylvania, as well as the third federal district courts. I've been a practicing attorney for over 17 years. My concentration is currently with complex and high conflict divorce, family law, and estate planning cases. Before opening my current firm, I did several years as an associate with David Kessler and Associates. There, my primary responsibilities were complex commercial and civil litigation. And before that, I did a clerkship with the Honorable Eugene Austin in Bergen County Superior Court. He was, at the time, the supervising judge of the special civil part, which meant that we handled all the cases in special civil, small claims, and landlord tenant for Bergen County. So it was a high volume court, dealt with a lot of commercial collection, landlord tenant, and civil actions. As you can see, I have a very generous and wide range of experience prior to opening this practice and our current concentration. As you may or may not know, the Micklin Law Group is concentrated in divorce, family law, and estate planning issues. That is our sole focus. We have 2 additional associates. Rachel Isaacs is our lead associate, and Richard Buglia, who recently joined our firm, and both graduated from Widener University at the same alma mater that I attended. And additionally, we have several support and paralegal and paraprofessional staffs to try to accommodate all of our clients' needs. Okay, so let's start discussing some of the people. This will probably be the briefest section of what we're going to cover today. I'm going to touch on the basic people you primarily will come into contact with in a divorce case. There's certainly always variations. Excuse me, every case is always going to be different, and depending on the complexity of the case and the complexity of the issues, you may run into other people. But these will be the general ones that you should be familiar with, the general people that get involved in the average divorce cases. So the first one, obviously the judge. Every case will have one judge assigned. And the intention in New Jersey, at least, is that that judge is supposed to be the judge that hears the case throughout, not only during its litigation, but it's intended to have the same judge hear the case post-judgment, meaning after the case is completed. Anytime an issue is raised, it should go back to that same judge. The obvious intention is that that judge should have a familiar background on the issues in the case and would be better equipped to hear it. Unfortunately, in practice, that doesn't really happen that often because judges get rotated, and depending on the level of complexity of cases, the courts will vary where each one gets assigned to post-judgment. But generally, you will have the same judge throughout the initial divorce case. That usually does not change absent some unforeseen circumstances. Judge, as you can see, is an attorney. It is a licensed practicing attorney, or not practicing, I'm sorry, they're actually not allowed to practice, but they are a licensed attorney. In order to be a judge, you need to be an attorney for a minimum of 10 years of time. Most judges you will find have been attorneys for significantly longer than that. I believe after 10 years, you're not as highly qualified to be a judge as you might be after, say, 20 or 25 years. So you will generally not see too many attorneys going onto the bench right after 10 years of practice. But that is the minimal amount that they need to have. Judges are appointed to their position. They're appointed by the governor. After, I think it's 5 years, they receive tenure so that they actually cannot be removed. But it's not an elected position. It's not, you don't apply for it. It's an appointed position. It's not political, at least not after the appointment. I'm sure a little bit goes into that. But now the judge is essentially the decision maker of the case. If you put a motion into your case, as you're going through the process, when issues need to be decided, what's called pendente lite, which is Latin for while the matter's pending, it's going to be the judge who's making these decisions for you. There's not that many decisions that really are generally made by the judge before trial because there aren't that many issues that need to be addressed throughout litigation. Most of it is document exchange and settlement negotiations, which we'll talk about much later. But when there are issues like custody and parenting time issues or temporary support issues or any kind of emergent issues, it would be the judge that's assigned to your case that would be making these decisions. The judge has a law clerk, which is technically called a law secretary, that will assist them. This person is a law school graduate. Sometimes they are practicing attorneys or licensed to practice, but many of them graduate law school and are sitting for the bar during the same term that they are working for the judge. So they may not be technically licensed to practice law just yet. They are what I label here as the go-between. Um, you will almost never speak directly with a judge unless you were in court on the record. When you call, when you send letters, it will generally go through the law clerk. A lot of times you'll hear people say, "Oh, I spoke to the judge," or "My lawyer spoke to the judge." They really don't mean that. Most of the time they're actually speaking to the law clerk, and the law clerk is speaking to the judge. The law clerk may relay a message from the judge, but generally not going to speak directly to them. Then there's a court clerk. This is a person usually you'll see sitting next to the judge. Um, they are in charge mostly with doing the court calendaring, scheduling the cases, making sure that the recordings are properly activated. It's not as common. You don't always see a court clerk in a courtroom, um, but in most divorces, I think you will. Now, there's a probation office, and inside the probation office, you'll have probation officers and a case manager. This is the office that handles the uh, collection and payment of most, not most support, but of support obligations, the majority of support obligations. If you have a wage execution or you're ordered to pay directly, it goes through the probation office and then it's sent to the recipient. Um, and then lastly, there's the clerk's office. Now, this is not only, it's the name of the office, not really the individuals that work in there. There's no necessarily a clerk of the family part, for instance, at least that you'll ever deal with specifically. But that's where your cases and your documents go for filing. I put a note here that the people in the clerk's office, they are very helpful, but they're not lawyers. And this is important to remember because quite often, unfortunately, they are trying to help the litigants that are calling up that are representing themselves. And in many cases, they actually give you advice that may not actually be accurate. Again, they're trying to be helpful, but because they're not like attorneys, they just often don't know maybe the specific issues that arise or maybe a unique issue to your case. So you really got to be careful when you are speaking to people in their clerk's office. You know, most of the time, they'll even say that they really can't give you advice, but they try to. You just got to be careful with whatever information that they're giving to you. Moving along, now we're going to move a little bit into the papers. What type of documents you have, what they mean, and what you're supposed to do with them. All right, so let's go to basic pleadings. A pleading is just a term for a legal document that's filed inside of your case. You'll see on the one side there's plaintiff pleadings. Plaintiff is the person that begins or institutes the lawsuit or the divorce action in this case. And then on the other side is the defendant. Now, what's important to remember is these designations do not change. If you file a divorce case and you are the plaintiff, you will always be the plaintiff. So 2 years later, if the defendant files a motion, maybe to change child support, for instance, even though that defendant is instituting the motion, is filing the motion first, he or she is still considered the defendant of the case. So in your papers that you write, you'll write that you are the defendant when you appear in court. You have to identify yourself as the defendant. All right, so let's take a quick look at the basic paperwork or pleadings that are filed in a divorce case. First, on the left side, you have is the complaint. And that is the initial pleading that starts all lawsuits in New Jersey. Divorces, personal injury actions, everything. But for divorces, you're starting with a complaint. Your complaint will generally allege what's called the cause of action or the basic reason why you were asking for a divorce. It will include what's called a wherefore clause at the conclusion, which is where you itemize or list the things that you want the court to give to you, like a divorce, child support or alimony, equitable distribution. If you want it, you have to ask for it in your complaint. If you do not ask for it, you cannot have it. Also includes what's called an affidavit of insurance, and it requires that you set forth the insurance that you currently have in place, and it's to ensure that by certifying the insurance that's in place, you are not going to change it without permission of the court or until the case is over. The complaint is generally a basic form, and I believe later in the presentation I'll go through a little bit of the different causes of action, but it's generally going to be a basic form. And I tell a lot of clients this, and it's sometimes disenchanting to them, but that it's not a very important document. I mean, you need to put in certain things to be entitled to receive certain things, but the form and the statements are pretty basic. Almost every complaint that you file for divorce is going to be similar to the other. So while it's an important document, it's not going to greatly affect your case one way or the other. Now, once a complaint is filed, the defendant on the right-hand side files what's called an answer. Now, staying on the right-hand side, an answer can include, but doesn't always have to include, counterclaims and third-party complaints. Counterclaim is just, it's sort of like the defendant's complaint against the plaintiff. The complaint, initially the plaintiff files his or her complaint and serves on the defendant. The defendant can serve what would be their complaint for divorce inside of their answer. Let's say, for instance, you filed divorce asking for reconcilable differences. The defendant can file a counterclaim for extreme physical cruelty or adultery. There could be additional claims such as dissipation of marital assets or abuse or assault claims for monetary damages. That would go into a counterclaim. That goes as part of the answer. Now, there's third-party complaints. They're not as common inside of a divorce. You'll see under here affirmative claims and parents and entire controversy. Third-party complaints are complaints that are drafted by the defendant, but they're naming a lawsuit against a different person, not the plaintiff. They're affirmative claims that the defendant has against somebody else that's related to the divorce, which is why I list parents here. That's one of the most common third-party complaints you will find in a divorce. A lot of cases have where parents either give a lot of money to a family or they co-own property or businesses together, and the divorce court doesn't have jurisdiction over just anybody. They have to be part of the lawsuit. So if you're married to somebody who owns part of a family business, in order for the court to have power over that family business, you need to bring either the business itself as a legal party or the owners or the parents in to be divided. Now, quickly underneath there, as a term, you see entire controversy. We won't go greatly into entire controversy. It's a very intricate, very important legal doctrine in New Jersey, and that basically says that if you have a lawsuit against somebody, you need to bring all of the lawsuits that you would have against that one person in the one lawsuit, or you're going to be prohibited from ever doing so. So let's say, for instance, you are in a divorce case against your spouse, but maybe you had a landlord-tenant obligation before you married them where they breached a contract with you. In order for you to sue them for the breach of contract, which really has nothing to do with the divorce action, you may still need to bring it as a counterclaim or possibly a third-party complaint, or you may be barred under entire controversy. Again, an issue much further unrelated to what we're talking about, but very important to be aware of. Returning back to the left side, the plaintiff's pleadings, you'll see answer to counterclaim, which is, again, answering the claim that the defendant filed. And usually that's going to just be a general denial, as long as there is a denial of the claim. Usually you're not going to admit a claim, at least in the beginning of the case. Now, the last few, you'll see entry of default. If you file a complaint and there is no answer filed, then you file an entry of default, and that closes the defendant's ability to file an answer. They are then prevented from doing so unless they file certain papers, which we'll discuss later. A final judgment of divorce is a proposed form that you send to the judge. One, either if there's been an entry of default, or sometimes even if you're having a final divorce. And that is setting forth usually certain terms about getting divorced, but also it may or may not include terms of settlement that have been reached. And if the judge actually made a decision in a trial, the final judgment of divorce may actually include the trial terms that the judge decided also. And then lastly, and it's not in order of filings, but there's a complaint information statement. Sorry, that's a typographical error. It's actually a case information statement, a CIS. This is a very important document. It's probably the most important document that you will file in a divorce case. It is a document that the court uses to review and determine all support obligations, both inside of your divorce as well as after the divorce if the issues come up later. If there's going to be support issues after your case, such as modification issues or college contribution issues, they are going to look to your case information statement that was filed during a divorce. You may actually have to file another one after your divorce. Um, and it's a very important document. It's also a very difficult document to complete. I tell all my clients, and I'll tell anybody who's listening now, it's got to be an accurate document. You need to put in the accurate information, but it doesn't need to be exact. They're going to ask you for a lot of information about your finances, a lot of information about your expenses. You can't possibly get it exact, and I tell people don't agonize over it, but make it as accurate as you can. There is a portion of this case information statement when you're filling it out that allows for footnotes. You'll see little boxes at the end of most of the lines. If you're ever doing a case information statement by yourself, these are very helpful places to put additional information that may not fit into a specific number, category, or a specific answer, but you may need to explain your answers, or you may need to explain why you can't answer certain portions of it, and you would use the footnotes for that purpose. Now, through your divorce case, you will be required to amend it anytime the information changes. You should make an amendment. Also, if you do have trial or you're going to a trial, you're going to be expected to amend it before the trial date with most updated information also. Okay, continuing the papers. We have motions and orders to show cause, OSCs, orders to show cause. Now, they're in many ways similar to one another, and the forms are similar, but they're unique and distinct in when and how they're used. So motions, for instance, on the left side, you have notice of motion, certification of client, certification of mailing, and form of order. These documents are required in almost every motion that you file. The notice of motion is a form document. It must include the specific relief that you are asking for. If you do not put what you're looking for in the notice of motion, no matter how well drafted this motion is, you will not get it. The certification of client is the statements that support the notice of motion, that support the reason why you are entitled to get whatever it is that you're looking for. The certification must be based on personal knowledge. Now, that's often difficult because sometimes you're speaking about things that you may not specifically know. You may be alleging things that you believe to be true or that you heard to be true. And a little gray area about how much can actually be personal knowledge, but it's got to be the best, most accurate as possible. The certification of mailing, it's a general statement. All you're doing in this document is telling the court how you served copies onto the other party. Motions, we'll go into a little more later about how they get filed and how many copies get served and things like that, but they do need to be sent to the other person. You need to be able to show the court that you did it properly and that you have proof that you did it. Lastly is the form of order. This is something that you draft or an attorney drafts with the motion, and it's for the judge to sign, and it's going to be what the judge is saying that the judge granted or gave to you in response to your notice of motion. It should mirror the requests set forth in your notice of motion so that it's easier for the judge if they're going to grant what you ask for, that it's all there. The order is very important that it be drafted properly because, again, it's going to be what becomes the enforceable part of your motion. Lastly, on that side, the consent orders, that is an agreement between two people, and then it's submitted to the judge. The judge signs it, so it becomes a court order. Now, turning over to orders to show causes. Now, orders to show causes are in and of itself a motion also. It's just a very different, unique type of motion. The purpose of filing an order to show cause is you're saying to the court that it's a two-pronged test that you need to show, that there's an emergent need or an emergency and that irreparable harm will occur, meaning that if the court doesn't do something, you will be harmed in a way that cannot be corrected. Now, what that standard is or what meets that two-pronged test is different in every case and hard to say. Unfortunately, the courts have generally ruled that financial issues are not emergent. So let's say you're a stay-at-home spouse and your spouse moves out and leaves you with no support and no access to money. You file an order to show cause asking to get emergent relief for finances, you're probably not going to get it. But then the flip side comes, I've seen orders to show causes granted around the holiday times when a client is saying that they need to have Christmas parenting time. So it's going to vary depending on the judge and the issue. So the documents that you generally need to have in order to show cause, you need to have the notice of order to show cause. Now that's similar to the notice of motion, but there's a specific prescribed form that you need to use that the court rules have, because it spells out in great detail the type of notice that you're giving to the other side. It spells in great detail what their rights are in response to what you're filing and what they need to do. So if you do not have the prescribed form, you may not be able to file the case even if it is an emergency. Inside of that, you will also have whether or not you're going to be serving notice on the other party. The certification of mailing, you'll see 2 numbers down, like you have in a motion. You're supposed to indicate in the order to show cause whether or not you gave notice to your other side. Now, order to show cause is one of the exceptions in our legal system that does not always require that you would give notice and a copy to the other side before going into the court. You can go in under certain circumstances without letting the other side know, which is a very effective tactical way to get a lot accomplished. But again, depending on the circumstance and the level of urgency, depends on whether or not you do need to give notice. You can't just not give notice because you didn't get away with it, because that may defeat the order to show cause in and of itself. So, sort of a balancing act. Certification of client, similar to the notice of motion, it's going to be based on personal knowledge. Certification of mailing, telling how you served notice if you gave notice. The form of order to show cause, that is the order that the court may give you. See, in orders to show cause, you'll see there's 2 forms of orders. There's a form of order to show cause and the form of order rule specific. Because there's going to be 2 decisions in this case. The first is going to be whether or not the court grants you an emergency hearing. So you submit a form of order to show cause for the court to say yes or no, we will bring you in quickly to decide this motion, or yes, we will grant you specifically something that you're asking for, and that's on a temporary basis. Then there's going to be a final decision, may come a couple days later or even a couple months later, and that's a form of order you need to submit that says the final decision that was being made. It's a little complicated, and again, the purpose of today is really just to give kind of a brief overlay. Lastly, you're going to usually need a letter brief, which is just a document where you set forth what the law is. This shows you're entitled to the emergent relief, why it is emergent, and if there's any specific decisions that tell the court how to make decisions or whether or not they should be granting what you're requesting. Next, the papers, discovery. Discovery is one of the most time-consuming, difficult parts of a divorce case. I'm not going to spend a great deal of time on this because they're very complex issues, and you could spend hours just talking about these. But basically, you have interrogatories, notice to produce documents, appraisals, and then on the other side, we have depositions and pre- and post-marital issues. Interrogatories are just written questions. They are served on the other side, and they have to be answered within 60 days. They're often, as I note here, standard in form, because most of the information you want in a divorce case is kind of standard. We know what we're looking for. There are custody interrogatories. When there are child custody issues, you serve specific written interrogatories, questions about those. And then for business evaluations, if there's business interests that need to be evaluated, you may have specific questions that you want to know about that. You do these first, usually along with the next line, a notice to produce, which is a request for documents. You specifically are just outlining the documents that you want them to give to you. Bank statements, retirement accounts, credit card statements, things like that, to verify what is or is not required to be distributed. Appraisals, some cases have them, some don't. Business appraisals, obviously, there might be valuable personal property like collections or antiques. And sometimes there's employment appraisals. And what I mean by that is if a person is not working to their full capacity or you're alleging that they're not, you may need to have an evaluator determine whether or not a person could or could not be making more money than they actually are. And then there's, on the other side, there's depositions. That is questions taken under oath. The person that is answering them is usually one of the parties in the case or important witness, and they're answering questions under oath. And then the last one I have is pre or post marital issues. That is because a lot of times you may need to do specific discovery about assets that may have complicated pre and post marital aspects. Like, let's say you marry somebody that owned a house before you married them, and then you lived in that house for 20 years. So there's going to be a value to the house before they were married and a value to your house after. Some of that's marital and distributed, some is not. So you may need to actually have discovery on that issue alone. All right, let's move into the process. Hopefully we're running on time. A little, yeah, I'm about on time here. Hopefully we'll stay on track. Okay, so the process. Who files first? I did this because this is a question I hear of most often. Everyone wants to know who should file first. Is there an advantage? And generally, my answer is it doesn't necessarily make much of a difference in most cases. There are some issues to consider. First is cost. It is slightly more expensive to file first. The filing fee for a complaint is, I think, $260, where an answer is, I think, $190. Depends on what the cause of action that you're alleging is. For instance, if you do want to allege something like extreme mental physical cruelty, if you don't file first and the other person files for a divorce, it begs the question of, if you thought your situation was so bad, then why didn't you file? Doesn't determine issues, but again, it's just an issue to consider. And then lastly is custody. If there are going to be significant issues like custody, or there are custody issues that need to be decided, unless you file a complaint, the court has no power to make any decisions. So you may need to file first so that you have the ability to get to court and address the issues that are significant. And then the thing to consider also is the timeline. A lot of people, for instance, when they file for divorce, may want to go to mediation, or they may have significant issues to resolve, and they don't want to file because once you file, you're under the court's time frame, you're under the court's schedule. If there's a hearing, the court wants you to come in, whether you can get off work or not. So if you think there's a chance that important issues can be dealt with outside of court, then maybe you hold off on filing. And then there's the service and response time. You need to figure out if there are issues. You file a complaint, for instance, the other party has 35 days from the day they get it to file an answer, which is the response. We talked about the answer, the counterclaim. So they can take up to that month. Sometimes they even ask for an extension. So the process begins by filing the complaint. It starts to move once the response is filed, which can be anywhere from 1 or 2 months after that date. Paperwork must be served properly. When you do serve the complaint, if there's anybody here that's planning to do it themselves, there are certain court rules that prescribe exactly how a complaint can be served, and you need to be mindful of that. It must be served by somebody who is over 18 years old. That person cannot be connected to the litigation in any way, so it cannot be you or your child or your attorney. It must be completely unresponsive or unrelated to the litigation. And it also needs to have a summons, which I didn't talk about, which is just a form that tells them how and when and where they need to file their response. The process. Next, the motions and orders to show causes. We already talked about the document. Now let me give you a little insight about what you're supposed to do with them and how they work. All right, so filing motion goes to the clerk's office, which is what we talked about on the very first slide. You need to serve them, as we said in the paper part of this discussion. Your certification of service will explain how you sent them. The court rules now require that you give the other party, your adversary, 2 copies of your motion. The purpose of that is that if that person has an attorney, the attorney is not burdened with the cost and time of copying and sending it out to the client. So you have to give 2. I also recommend sending a copy to the judge as a courtesy. It's not required, but because so many motions are filed, it's often a high volume process. that it doesn't always get from the clerk's office to the judge as quickly as you might want it to. So sending a copy or dropping off a copy to the judge, or the judge's law clerk, I should say, will often help you ensure that it's properly addressed and timely. Return dates. That is the date that the court's going to hear your motion. Now, generally, most family court judges hear motions on an alternating Friday schedule, which unfortunately means that every judge in every county will be hearing motions on the same day and time for all your cases. So for a practice like ours, where we're divorce concentrated, we may have several motions on all at the same time in different counties that require a little bit of scheduling. When you file your motion, you are supposed to put in there the requested return date, and that goes in your notice of motion. That doesn't mean that that's what the court actually grants to you. That just means that you're requesting it. The court will notify you if they're not giving that one. If there's another date, they'll send you what the new date would be. Oral argument. Not every case has oral argument. That oral argument, obviously, no, I shouldn't say obviously, but that is where you appear and you argue to the judge what you put into your papers. Now, you're not allowed to argue anything that wasn't in your papers. So a lot of people say that oral argument really is just a waste of time if you can only argue what's in your papers. But it gives the judge a chance if there's questions that need to be resolved. Also gives you or your attorney a chance to highlight certain facts. Sometimes things have changed, and you can bring that to the judge's attention so that they can make the most informed decision at the time. I usually recommend, and our office always calls the court in advance, a day or two, to find out if there is going to be oral argument or not. Sometimes courts don't know before a day or two whether or not they're having argument, but it's not a guarantee. Now, orders to show causes, not much different. Again, filing is a little different. Sometimes you will actually file in the judge's chambers first, and they will determine whether or not it's going to be granted. And if it's granted, then they tell you to go to the clerk's office and file it. Here, I often recommend you call the judge's chambers before filing an order to show cause. Excuse me. A lot of judges will have their own procedures. Some will have forms that they need to fill out. Some will take information down, and it's always good to be in compliance with what the court wants. Flip side is that sometimes it's good to just go in, because there's sometimes a greater chance that the court will do something if you're standing there as opposed to if you're on the phone. So it's a balancing issue. The service of your order to show cause depends on the urgency. I recommend that you read the court rules. Like I said earlier, sometimes you do need to give notice. Sometimes you do not need to give notice. It's better if you don't need to give notice, because then there's nobody arguing against you, but that can also defeat the application if you weren't entitled to come in the first place. Return date is an expedited return date. I forgot this on the motion part. When you file a motion on the left side here, it's generally called a 29-day motion, which means the court will schedule it 29 days after they get it, and on the next alternating Friday that the courts hear oral argument. So it's usually a month and a half at a minimum before your motion is going to be heard and decided. Whereas an order to show cause may be heard immediately. It could be heard in a day or two, or it could be sent as a motion 29 days later. That's going to be up to the court. And oral argument, again, it's also up to the court. Usually, if your order to show cause is granted in some form, there is going to be oral argument at some point in time. It may or may not be the day you walk into court, but it will be at some point. Do not mail orders to show causes to judges. They will almost automatically flatly deny it. The rationale is, if it's so urgent, you want to take in 3 days to mail it. So heed caution there. Continuing with the process, let's talk about how discovery works, what it is, what you do. Discovery, as I briefly said before, it's the exchange of information, and it's really the heart of a divorce case. It can only begin after the defendant files their answer, his or her answer. So if you serve your complaint and you wanted to get a jump on the defendant, let's say, and you wanted to burden them with paper or get the case moving quickly and you send it out, it doesn't matter. It's not even going to be effective, because it's got to be after they've had a chance to file their answer. Discovery will generally last at least 3 months. As I said, interrogatories are 60 days from the day they get them. Documents are to be responded in 30 days, but at a minimal, it's going to take you 3 months. Most of the time, it's going to take a lot longer. Even in a simple divorce case, you could look for 6 to 8 months. There is a prescribed time period. The court will tell you when your discovery period is ended, which means you can no longer exchange any information. You will be told this in the beginning of your case. So when that date is approaching, if you are still in the middle of exchanging information or there's outstanding information, you need to extend it. You can extend it either by getting a court order asking the judge by motion, or you can do it by a consent order, which is an agreement. But either way, it's got to be done. It's got to be done in advance of the expiration, and and it's the most important thing to keep a track of. So always keep that date in mind of when your discovery is going to be ended. The process continues with hearings. Now, all cases are going to be different, but you will generally have the following hearings. May not have all of them, but you're usually not going to have more than what these are listed in front of you. Excuse me. First is a case management conference. You may have more than one of these. They will usually be the first thing that's scheduled in the case, and it's often the second to last thing, which means right before a trial. That case management conference is more of a status scheduling hearing. The court brings you in, find out what has happened so far, meaning what pleadings have been filed, what discovery has been exchanged or served, and then they schedule from that point what needs to be completed to end the case, the divorce case. So let's say you filed an answer, a complaint and answer, but discovery hasn't been scheduled or served. So the court will say, okay, serve discovery and answer interrogatories in 60 days, notice to Bruce in 30 days, come back to court in 90 days. That will be another case management conference. So in 90 days, the court gets to see what's happened. Have we exchanged a discovery? Did we do what we were told to initially? And where do we go from this point? Second is final hearings. And this is common. You'll have a final hearing that is not a trial. If a final hearing is held where a case is settled or there's only a plaintiff, the defendant didn't file an answer. Final hearings are very brief, very simple process. The court will ask you a series of questions about the paperwork that you filed just to make sure that it's true and accurate when you filed it. If there's a settlement agreement, they'll ask you certain questions about the settlement agreement to ensure that that was fair and that you believe it's fair of how it was entered, but they won't actually ask you about the terms of your agreement. There are default hearings. A default hearing can lead to a final hearing if a defendant has not filed an answer. The default, you may recall from the paper portion of this, is where they file papers because the defendant did not answer, and that closes out your ability to answer. Then there's a trial. Now that's obviously the last stage of litigation. Very, very few actually go to a trial. I think it's 1% of all litigation, divorce and civil litigation, goes to a trial. Of that, so 99% of them settle. Of the 1% that go to trial, I think 98% of those cases settle while they're at trial. So the large majority of cases do settle. Doesn't mean all of them will, so you may have a trial. Always plan to go to trial, so that way if your case does not settle, you're prepared for it. Now, motion hearings, these are separate. These can come at any time during your case. It's not in the order that we're talking about. Motions have different types of hearings. There's oral argument, there are contempt hearings, and there are Harrington hearings. Oral argument, we've already touched upon. That's where you go in and argue to the court about the statements you made in your motion. Contempt hearings, they're very common hearings. If you have a court order, usually resulting from an earlier motion that you filed, and the other person didn't do what they're supposed to, then you file a motion to hold them in contempt. And the court will have a contempt hearing to determine whether or not they did fail to comply and what sanctions should be imposed. The last is a Harrington hearing. These are not very common, but they're common enough where you should know what they are. A Harrington hearing is a hearing that a court has when one person is alleging that they reached a settlement with the other person, but that person, the other person, denies that or claims that the matter was not settled. Courts obviously don't know who's telling the truth, so they have what's called a plenary hearing, which is a short but a complete trial on the issue. Harrington is just the name of the case. It was Harrington versus Harrington, where the court was first charged with the responsibility of determining whether or not an agreement was in fact reached. Again, hopefully never a situation you find yourself in, because a Harrington hearing is almost like a mini divorce, because in order to determine whether or not there was an agreement, the court, you have to go through discovery, and you have to have case management conferences and settlement conferences, and it gets to be a very difficult, taxing process. Okay, this is going to be the final portion of the seminar. It completes the process section, and that is settlement. Now, although a divorce case, most family cases are considered litigation, most people expect them to be litigious and full of arguments and battles. The whole process itself in New Jersey really is geared towards helping parties to sell their cases, which is why you only get a trial at the very end of your case. And rarely will you have many decisions made before that point. Now, there are mandatory settlement processes that the court will put you through, and there are elective processes, ones that you can choose. Under the mandatory sections, you'll have first is an early settlement panel, some called ESP, some called MESP, mandatory early settlement panel. This is a process, and it's actually a very good, helpful process in most divorce cases. This is where the court brings in two experienced family law and divorce attorneys that practice in that county, who volunteer their time, and they will listen to your case. Each person or each attorney will submit in advance a proposed settlement, or how that side believes the case should be resolved. They will review that and then speak to the parties. If they will then tell you what they think based on the facts of the case, how it should be resolved. The purpose is that they're probably the first time you get an objective view of your case. The two lawyers come in, they're not being paid by anybody, they're not being paid by the court, they're not being paid by the clients. So they have no horse in that race. Whereas the lawyers and the parties all have people and interests to protect. So here you get two well-versed, experienced attorneys telling you what they think you should settle for. The only limitation is that it's very limited. You'll go in and you may be one of 10 early settlement panel hearings, and you may only get 15, 20 minutes. Your case may require a lot more than that. But it's a very good starting process. Many divorce cases are resolved at an early settlement panel. If not resolved, a lot of cases, at least a lot of issues are resolved, and you reduce the amount of litigation. Following the early settlement panel, you will have economic mediation. This is where you and your other party choose one attorney as opposed to two. But this attorney will invest as much time as you require. The process is unlimited. The first 2 hours that the attorney provides is a courtesy that they're providing through the court system. They're not charging you. But after that, you will be paying an hourly attorney rate. And you'll know what the rate is before you even choose the attorney, because the court has a list of those individuals that volunteer for economic mediation. So this is good. It follows the early settlement panel, so you now have some sense from the panelists at the early settlement panel about your issues. You may have a little more clarity about the strengths of your position, so you might be in a better place to speak about final resolution, and that's what you have with the economic mediation. Following that, most counties have what's called intensive settlement conferences following the economic mediation. And this is basically where you just spend the whole day in the courthouse. You sit in the hallway or in a conference room, and you just work out your problems. You don't often have much time before the judge. Sometimes the judge will check in, see how things are going, see if you need any help or if they could help resolve issues. But generally, the judges stay out of it, and the lawyers and or the parties sit in the hallway and try to work it out. I'm not a big fan of the intensive settlement conferences because it creates a lot of problems. The divorces alone are very, very emotional and stressful for clients. Settlement discussions that are lengthy are very difficult and trying for clients because you're dealing with these difficult issues for long periods of time. It brings up an issue of disabilities, whether or not a client can actually be under a disability when they're so emotional or confused or tired and hungry because you've been there all day. It's not, and I'm giving you like the worst version of this because not all cases go this way, but the more difficult your case is, the more intensive the intensive settlement conference will be. And you and or your attorneys need to be mindful when it's not going to be productive or when you may not be in the right frame of mind to continue to talk about it. And if that's the case, you tell the judge that it's got to end. That you're just not able to manage it at this point. Then there are elective processes. Some of them are kind of new. You'll hear a little bit about them. The first is arbitration, which is the newest area of alternate dispute resolution, meaning outside of court and trial. The good thing about arbitration is it is binding. Both of you go in agreeing to be bound by the arbiter's decision. It is quick, or usually it's quicker. You get a date much more quickly than you will inside of a court. Courts will take at least 18 months, if not more, before giving you a trial date. And they don't always keep their trial dates. Um, it's a lot faster because it's often more, it's often less formal than a trial. You can present evidence easier. You can agree to a lot more than you can if you're going into court. Most often, you're picking a very experienced family law attorney. In many cases, you're picking a retired family court judge to serve as your arbiter. So you're getting the same type of person who would be making your trial decision to make your arbitration decision, but you can do a lot quicker. Now, obviously, again, you're paying this third person where you don't have to pay a judge, but the benefits is you get into arbitration quickly, you get through arbitration quickly, and it's binding, so it's over. Then there's mediation, and that's a very popular alternate forum to try a divorce case or to resolve a divorce case. It is non-binding most of the time, so you're going there to try to resolve your differences. Mediation you have to be careful with. I'm not always a huge fan of mediation because if you have people who could successfully mediate their differences, they're reasonable enough. You don't necessarily need a mediator to do that. You should be able to do it on your own. But also, mediating a divorce case is a very trying, very time-consuming process if done correctly. The mediator's job is not to tell you what you should or should not agree to, but is there to tell you or help you to reach your own agreement, which in and of itself is a very taxing issue. Divorces, as I've said before, are very emotionally charged. They have very complicated, very difficult issues that need to be resolved, and having two people come to an agreement on that can take a significant investment of time. And the problem with a lot of mediators is they're not really there to put in that kind of time, and instead they sort of try to lead you in the direction of what the law says you're entitled to or what the law would decide. So it's sort of like, if you go to mediation, but if the law would not support you getting alimony, the mediator may say to you, your request for alimony is unreasonable because the law doesn't really support it, which helps expedite the mediation process, but really isn't the appropriate steps for a mediator to take. The mediator is supposed to really find out why they want alimony, ask the other person how they feel about paying alimony, and see if there's a way to bridge the gap between the two of them. If you get a mediator who understands his or her role and is willing to do that, and you're willing to invest the time, then it's a great process. It's a lot easier and less stressful, less expensive than any form of litigation will be. But again, it's just very important that it be done properly. That being said, I'm going to just take 1 second to close this out, and then we'll just field some questions.